Honorable Nominee, congratulations and you're welcome. Lady, you've been in this practice for 26 years, and you've dealt largely with issues of dissolution of marriages. Lady, family law cases increasingly involve complex constitutional questions regarding gender equality, children's rights, and traditional versus modern family structures. Given your very extensive experience in family law, how do you view the Supreme Court's role in balancing traditional family structures with evolving constitutional principles of gender equality?
Honorable Chair, can the question be clarified?
The question is seeking to know how you intend to use your background as an expert in family law to deal with issues of constitutional matters, especially people are now making more or concentrating their attention on gender equality. How do you marry the two? How are you bringing your rich experience on family law to deal with issues of gender equality?
Thank you, Honorable Chair. When it comes to family law, the principles are applicable equally to men as it does to women. Because when it comes to distribution of marital property, it is not based on gender, even though it may seem so. It may seem so, but the law is not based on gender. Because it says, Article 22 says that assets acquired jointly during marriage are to be distributed equitably. And whether, irrespective of their gender, that is what the provision is. So it is not in any way discriminatory of any gender. That is my answer to the question.
Just a follow-up. Have you handled cases where the man seemed not to have properties, but the woman seemed to have properties, but they had these properties during the currency of the marriage, and then when it came to distribution, there were issues because the man was now requesting that the properties be shared equally?
I do recall that there was a case before me where the man did not have properties, but the woman did. And I gave the man part of the woman's properties. The man did not have properties, but the woman had properties. And the man was entitled to a share in the woman's properties. And that is exactly what I did. Thank you very much.
Thank you very much, milady. Milady, the Supreme Court frequently addresses cases involving children's welfare that require balancing parental rights, state intervention, and the best interest of the child. Lady, how can the Supreme Court interpret constitutional provisions regarding children's rights when they conflict with this parental authority or cultural practices?
Thank you, Honorable Chair. The law is clear that in every matter affecting children, the welfare of the child is the court's primary consideration. So in all matters affecting children, it is the welfare of the child. That is the primary consideration. So that is what the law says, and that is what is applied in the courts. Thank you, Honorable Chair.
Lady, have you had the occasion of dealing with a matter that the welfare of the child, although very key, the Constitution perhaps also had a position, and therefore you felt a bit conflicted, especially as a mother?
Can I have a clarification of the constitutional conflicts? I'm not too clear on the conflicts. Thank you.
Well, maybe there was a set, like you just give a response, and then there was the basis for you to proceed to say that, well, the law is the law. And so I need to proceed to give a judgment or make a decision or a determination based on the law. But you also felt that at this point in time, maybe you could have considered the child's welfare more, but it still conflicted with the law, and therefore you proceeded to deal with the matter the way you had to deal with based on the law.
What I said was this, that where a child's welfare is in conflict with a parental authority, you said, then in that case, the child's welfare will be considered. Because in considering the child's welfare, you must find out whether or not what the authority the parent seeks to exercise is in conflict with the rights of the child. And if it is in conflict with the rights of the child, then you need to prioritize the welfare of the child. That was what my explanation was.
Well, I think it's well understood. Lady, this will be my last question. Is how do you envision the Supreme Court's role in developing constitutional standards for ADR, alternative dispute resolution mechanism?
Thank you very much, Honorable Chair. The ADR Act is the standard for resolution of disputes by either mediation or arbitration. And I believe that this is what is enforceable, even in the Supreme Court. If the matter should probably go to the Supreme Court, but not on the merits, because you cannot appeal against an arbitral award, for instance. You can only seek to set it aside on procedural or other grounds, but not on its merits. There's no appeal in respect of that.
Are there any recommendations you would want to make in reference to ADR, the ADR mechanism?
Not immediate. I can't think of any immediately. Yes.
Well, my lady, I wish you all the best, and congratulations once again.